All right, because I got another case law. Now, this particular case is Collingwood versus General Electric Real Estate Equities, right? Now, this is from the North Carolina Supreme Court, 1989. All right. So I'm going to scroll down. And again, we're not reading the whole case. We only want to deal with things that are pertinent to the case at hand. All right. Now it says right here, it says to establish actionable negligence at common law, right? So in essence, what you're saying is that there's some type of negligence that was caused by Kevin. So it says to establish actionable negligence at common law, a plaintiff must show the following. Number one, that there, let me say number one, that there has been a failure to exercise proper care in the performance of some legal duty which defendant owed to plaintiff under the circumstances in which they were placed. And number two, that such negligent breach of duty was a proximate cause of injury. Now, I'm going to read this again, right? I'm going to highlight it and I'm going to read this again and I'm going to place their names into it, right? So to establish actionable negligence at common law, Jessica must show the following. Number one, that there has been a failure to exercise proper care in the performance of some legal duty which Kevin Samuels owed to Jessica under the circumstances in which she was placed. Number two, that such negligent breach of duty was the approximate cause of the injury. Now, reading this definition, how the court laid out what negligence is, I have to agree with what you said, Rodney, that Kevin was negligent, right? And not producing a waiver, whether it was verbal or whether it was expressed on the screen where people can see it. Now, in my opinion, I think it should be both. I think you should briefly tell people, you can say something like, view the waiver. You know what I'm saying? Be advised, it's a waiver. The waiver is coming across the screen. He could say anything like that, had a waiver that he has the right basically to use her image and likeness because she's a participant on his show. So I agree with what you just said right here, right? There's some level of negligence that was caused by Kevin Samuels because he was supposed to exercise proper care in his performance, right? He did have a legal duty that he owed Jessica to place a waiver there. He did. You know what I mean? Now, did that negligence cause her injury? Now, she's saying that it did. So to me, I think that she meets both of these requirements also. What do you think about that, Rodney?
Yeah, that could possibly be true.
Mm-hmm.
But I want you to finish to go on because if he was negligent for not putting a waiver, how can she get around his negligence if that's the case?
Well, all right, I'm glad you said that because hey, Rodney, you know me, you know I'm about to bring something else up. Now check this out. In this same particular case, right? I want to deal with this statement right here. The court said, and I'm gonna highlight this. Excuse me. It says we have held that the existence of contributory negligence does not depend on plaintiff's subjective appreciation of danger. Rather, contributory negligence consists of conduct which fails to conform to an objective standard of behavior. In quotes, the care an ordinary prudent person would exercise under the same or similar circumstances to avoid injury. Now I'm gonna plug in their names. So the North Carolina Supreme Court said that they have held that the existence of contributory negligence does not depend on Jessica's subjective appreciation of danger. Rather, contributory negligence consists of conduct which fails to conform to an objective standard of behavior. The care an ordinary prudent person would exercise under the same or similar circumstances to avoid injury. Now, again, this is why I said earlier that to me, just as much as Kevin had a legal duty that was possibly owed to her, now we discovered what that legal duty was, that there should have been a waiver inside his video. So yes, he does hold legal duty to her by giving her a waiver, right? But she also had some responsibility in this because like this this particular case law says the care an ordinary prudent person would exercise under the same or similar circumstances to avoid injury. Now, what is a prudent person? Now, I have a definition for prudent, right? Let me scroll up, and it says prudent, acting with or showing care or thought for the future. So a prudent person shows care, they show thought, right? It says similar will be wise, judicious, or even shrewd. So a prudent person will be somebody that's wise, somebody that's shrewd, right? So to me, and this is my opinion of it, right? It would have been wise or shrewd for her when she asked Kevin, can he see her? And Kevin said yes. It would have been wise and shrewd for her if she was a prudent person, right? For her to sit there and say, well, I wanted to make sure that only you can see me, right? And no one else. She could have said something as simple as that. She didn't. That's what any reasonable person would say. So what I'm alleging is that she has some contributory negligence in this. That's what I'm alleging. That's what I see. Now, I have something else for you too, Rodney. Something else I want to cover. Now, this is a different case that deals with the same thing. Now, this is Miller versus Miller, North Carolina Supreme Court from 1968. All right. Now, I'm going to scroll down. Again, we're only dealing with the subject at hand, y'all. We're not going to read this entire case. We only want to deal with, we only want to deal with the interpretation of negligence and contributory negligence, right? Just like we checked out privacy torts, we only want to deal with those things from the court. So I want to make that clear. And I'm almost there. It is right here. All right. Now, right here, 74, it says the rule in North Carolina is that an injured plaintiff, whether his case be tort or contract, right? So in this case, in my opinion, we dealing more so with a tort. But again, we just going off of speculation, off of the details that we have, right? Until we get this complaint. So it says the rule in North Carolina is that an injured plaintiff, whether his case be tort or contract, must exercise reasonable care and diligence to avoid or lessen the consequences of the defendant's wrong. If he fails to do so for any part of the loss incident to such failure, no recovery can be had. Now I'm gonna start this back over, and I'm gonna read it with their names, right? So I'm gonna read it with their names. The court says the rule in North Carolina is that an injured plaintiff, being Jessica, whether her case be tort or contract, right, must exercise reasonable care and diligence to avoid or lessen the consequences of Kevin Samuels' wrong. If she fails to do so for any part of the loss incident to such failure, no recovery can be had. So to me, it sounds like she's possibly barred from getting damages. That's what it sounds like to me, because I'm alleging that there's some contributory negligence there, because she had a duty to ask him or to state to him that she only wanted her image to be seen between those two, right? Not to mention, she verbally agreed to a verbal contract or agreement with Kevin Samuels to whatever his teaching lesson is, right? Whatever this teaching lesson is, she agreed to it and she said, okay. Now let's read on. It says, this rule is known as the doctrine of avoidable consequences, or the duty to minimize damages. Failure to minimize damages does not bar the remedy. It goes only to the amount of damages recoverable. It has its source in the same motives of conservation of human and economic resources as the doctrine of contributory negligence, but comes into play at a later stage. All right, now we're right here. Now I'm gonna read this in quotes. It says the doctrine of avoidable consequences is to be distinguished from the doctrine of contributory negligence. Generally, they occur, if at all, at different times. Contributory negligence occurs either before or at the time of the wrongful act or omission of the defendant. On the other hand, the avoidable consequences generally arises after the wrongful act of the defendant. That is, damages must flow from from the wrongful act or omission of the defendant, and if some of these damages could reasonably have been avoided by the plaintiff, then the doctrine of avoidable consequences prevents the avoidable damages from being added to the amount of damages recoverable. Now, again, I think Kevin has a very strong case, right? Now, if everything was laid out the way we're discussing it on this broadcast, Rodney, I think Kevin have a very strong affirmative defense of contributory negligence. I really do. And I have another reason just popped in my brain that I'm going to bring up in a second. But I want to know what you think.
Well, it depends on what type of claims she's bringing.
What, Rodney? Let's say she's bringing it similar to exact to what we're discussing.
Because to me it's two. Because now, if she would bring up negligence, whenever you're talking about the unauthorized use of an image, right, or likeness, so there's like negligence don't really have to be used. So that's what I'm saying. That's what I'm trying to go back to. It's what we're doing is pretty much speculating based off the hearsay we have.
Exactly.
Okay?
Yep.
So based off the hearsay we have, if I was working for Jessica, or if Kevin is sued for unauthorized use of a person's likeness and image, contributory negligence can't save him. And the reason why I'm saying it is because there's no negligence. He just unauthorized. He didn't do any type of negligence to her. He just used her image without her permission.
Right. So basically,
so
let me lay it out there. So basically what you're saying is it depends on the wording, the words, specific words,
how they structure their case.
Right.
Yeah.
How they right. I agree with you.
How they lay the case up, because if she say that he was negligent in not having a waiver or something like that, because it's gonna boil down to that waiver. Whenever you're dealing with, and that's what whenever the video was playing, I was kind of going through some reading,